Good afternoon. My name is Atwe Mchemwa. I'm a student at Great Zimbabwe University. I'm at Herbert Chitepo Law School, and I'm taking up jurisprudence as a course. My facilitator is Mr. Nkosana Maposa. I'm going to present on transitional justice, that is, its demerits and merits. The scope of my presentation will cover the definition of transitional justice, foundations of transitional justice, mechanisms of transitional justice. That is, we'll be touching on retributive, restorative, reconciliation, and other methods. We'll also talk about who is involved in the process of transitional justice. I'll also discuss the dilemma faced by new regimes in the process of implementing transitional justice. I will also talk about the fluidity of transitional justice as a concept, the position of women in the transitional process. Transitional justice is also an overarching concept. So we are going to discuss the overarching effect of transitional justice. We'll also dwell much on the Gabay versus Chiteppo jurisprudence. We'll also look at how the transitional justice affect property rights, how transitional justice may affect the government in terms of personnel in the times of transitional justice. By introduction, questioning about the purpose of transitional justice points to the merits and demerits of the concept. The answer is too often been assumed rather than explicitly articulated in the theory and gross human rights violations. Justice may be sought as redress for crimes, but it may be sought as a way of coming to terms with the past and building peaceful future. Justice, reconciliation, and peace are seen as inextricably intertwined. However, relatively few focus primarily on the promotion of human rights, democracy, and the rule of law, without situating their more effort on merits and demerits of transitional justice in peace-building context. The research paper we are discussing is going to define and give a brief foundation of transitional justice, discuss transitional justice, trust, and trust will also be directed to clarify the dynamics, dilemma, and the unsettling of property rights, workforce, position of women, socio-economic rights, among others. A 2004 report by the United Nations Secretary General defined transitional justice as the full range of processes and mechanisms associated with a society's attempts to come to terms with illegals of the past abuses in order to ensure accountability, to serve justice, and achieve reconciliation. Stifel advances that it is the conception of justice associated with periods of political change characterized by legal responses to confront the wrongdoings of repressive predecessor regimes. These may include either judicial or non-judicial mechanisms with differing levels of international involvement or none at all, and individual prosecutions, reparations, truth-seeking, institutional reform, vetting, among others. It is implied, therefore, that transitional justice refers to a broad range of judicial and non-judicial mechanisms which aim to address past human rights abuses and violations in a country or a society that is transitioning from a period of authoritarianism, conflict, or repression to a democratic regime that operates on the principle of values and accountability. Foundations of transitional justice. Transitional justice had its genesis in the aftermath of World War II and got organized in the early 80s up to the Aspen Institute Conference on the State Crimes in 1998, which was founded as a legal and human rights theory to deal with the issue of transition to democracy from authoritarian regimes at the end of the Cold War, and was coined by Chitepo in 1990. Criminal trials supplemented by other transitional justice strategies were expected to initiate human rights based on normal socialization in a weak post-authoritarian transitional democracy. It was initially envisioned as a depoliticized legalist language of right and wrongs, duties and obligations. Transitional justice is now superseding the dominant political language based on state interest, deliberation, and consensus. It has broadened its ambit from a thin legalistic, human rights-centric, incoherent, and often conflicting and contradictory theoretical peculiarity from diverse fields such as politics, science, sociology, among others. Transitional justice has gained global significance as an approach of dealing with the past in the aftermath of violent conflict or dictatorial regimes. What is described is an ever-expanding range of mechanisms and institutions, including tribunals, truth commissions, memorial projects, and reparations, with the aim of addressing past wrongs, vindicating the dignity of victims, and providing justice in times of transition. The mechanisms of transitional justice. The Western liberal tradition of accountability for crimes promotes an adversarial, prosecutorial, retributive model of formal legal justice. Based on this model, in the context of transitional justice, the international community has pursued prosecution through ad hoc international criminal tribunals, hybrid domestic or international courts, and the permanent ICC. Meanwhile, proponents of restorative justice promote the use of truth and reconciliation commissions or informal customary mechanisms where the focus is on rebuilding or restoring relationships and communities. The Truth and Reconciliation Commission was established in South Africa in the 1995 era, following the end of apartheid. The Transition Reconciliation Commission was tasked with investigating human rights abuses and violations which were committed during the apartheid era, and promoting national reconciliation, as argued by Tutu that true reconciliation cannot be achieved by denying the past. The TRC held public hearings where victims and perpetrators could give testimony, and it granted amnesty to those who admitted to their crimes and provided full disclosure. The TRC work was instrumental in promoting reconciliation in South Africa and stabilizing a framework of dealing with past human rights abuses. The International Criminal Tribunal for the former Yugoslavia, that is the ICTY, was established in 1993 to prosecute individuals responsible for war crimes, crimes against humanity, genocide, which were committed during the conflicts in the Balkans in the 1990s. The ICTY prosecuted a number of high-ranking officials and military commanders for their roles in atrocities committed during the conflicts. The ICTY work was instrumental in establishing accountability for past crimes and promoting the rule of law in the region. On the flip side, the Special Court for Sierra Leone was established in 2002 to prosecute individuals responsible for war crimes, crimes against humanity, and other serious violations of international law committed during the civil war in Sierra Leone. The Special Court successfully prosecuted a number of high-level officials and military commanders, including former Liberian President Charles Taylor. The Special Court's work was instrumental in promoting accountability for past crimes and establishing the rule of law in Sierra Leone. Of late, the International Committee has recognized that Western legal trials and a truth commission incorporating traditional indigenous rituals may be seen as a complementary strategy to support both retributive and restorative justice in transitional societies such as East Timor and Sierra Leone. Such pluralistic solutions is viewed as inadequate because it fails to break out of the dominant Western worldview of justice and to question the standardization of transitional justice goals and methods driven by external interventions. An alternative restorative justice model for modern societies should be built on the traditional, informal, restorative model of community justice practiced by indigenous peoples, often simplify and generalize the benefits of this approach to injustice. It is therefore disputable that the distinction between retributive justice in the Western formal legal system and restorative justice in indigenous informal justice mechanism is oversimplified, as it serves as a facade rather than to clarify the multiple complex human needs, expectations, and experience in relation to justice and reconciliation. Such is exemplified in the traditional Gatsata community, pardon my pronunciation, that is a community justice in Rwanda, which required the offender to appreciate the gravity of the damage she or he caused, and the agreed outcome was construed as a form of punishment. The punishment was one not so severe that it would interfere with the primary goal of reconciliation. Thus, the community court could be experienced as both retributive and retroactive at the same time. As argued by Joanna Quinn, while the more formalized Western models often allow for only one form of justice, which is retributive, restorative, or reparative, as traditional institutions seek to combine various of these and other elements in keeping with the values of the community. It leads to the idea that informal customary law practices might be more appropriate as a transitional justice model for genocide and other serious crimes against humanity can be misleading. It may be seen as imposing an unfair burden on survivors to accept restorative justice as sufficient when retributive justice would otherwise be expected. Vice versa, imposing primarily retributive legal justice mechanism may also be seen as inadequate by failing to take into account local community needs for restorative justice and reconciliation. This will take us to reconciliation as a mechanism in transitional justice. Reconciliation varies in meaning and significance. It can simply mean coexistence, or it can mean dialogue, remorse, apology, or forgiveness. Worth noting is that it is not an attempt to restore things to how they were before the conflict, but rather about constructing relationships in a way that allows everyone to move forward. Certain conditions should be in existence and are necessary for reconciliation to occur. There should be certain conditions, and reconciliation is often seen to be crucial in peace processes. And if peace processes are to succeed, reconciliation should be in existence, as it decreases the risk of further violence. Reconciliation does not imply amnesty for all, and does not mean massive forgiveness or rejection of judicial mechanism, but oftentimes it is so interpreted. In some countries, reconciliation and amnesty for perpetrators were sought as tools enabling some members of the political elites implicated in past human rights violations to escape accountability. The inclusion of provisions granting unconditional amnesty for all and calling for the establishment of Truth and Reconciliation Commission in the 1999 Long Peace Agreement represented a similar attempt. In Uganda, 1974, and Zimbabwe, 1985, the creation of reconciliation commissions mandated with investigating gross human rights violations under President Idi Amin, the Commission of Inquiry into the Disappearance of People in Uganda, and President Robert Mugabe, Zimbabwe Commission of Inquiry, respectively. The exercises viewed as was aimed at easing public pressure and improving international image of the leaders, as well as seizing the initiative and control over the evidence documenting the abuse of their regimes. The goals of transitional justice are diverse and multifaceted. Transitional justice seeks to achieve accountability for past rights abuse, promote reconciliation and healing, to prevent future abuses, and establishes the rule of law. The specific goals of transitional justice depend on the context in which it is implemented and the nature of the past abuses and violations it seeks to address. Attempting to heal divisions in society that arise as a result of human rights violations, transitional justice endeavor to bring closure and healing the wounds of individuals in society. It is particularly through the truth-telling, providing justice to victims and accountability for perpetrators, creating an accurate historical record for society, restoring the rule of law, reforming institutions to promote democratization and human rights is at the core of transitional justice. There is need for ensuring that human rights violations are not repeated and to promote coexistence and sustainable peace. However, in the aftermath of every conflict or authoritarian rule, people who have been victimized often demand justice. The notion that there cannot be peace without justice emerges forcefully in many communities, but justice can be based on retribution, that is punishment and corrective action for wrongdoing, or on restoration, emphasizing on the construction or relationships between the individuals and communities. Transitional justice measures were originally intended to be used as temporal tools to help consolidate peace in the interregional period for consolidating domestic rule of law in the post-transition state. There is a propensity, however, to conflate the two and treat the transitional justice measures as focused on mediating the immediate transition to democracy as given by other authors, rather than establishing a normative precursors for the transitional justice measures and rule of law by way of consolidating institutions like the judiciary makes the two as if are diverging. While transitional justice seeks to reconcile between the perpetrator and the victim through politicization of a legally determinable crime, rule of law through institution of judiciary, and the legal norm seeks to address the victims, perpetrators, and the vast majority of people who fall outside this narrow difference. The rule of law bases are procedural due to process, fairness, and the law. Practically, there are often real or perceived conflicts over prioritization, sequencing, and resources for transitional justice and the rule of law initiatives. In a 2013 article, leading scholars of transitional justice, Catherine and Kim, summarized the prevailing view as follows. Although better quality rule of law is neither a necessary nor a sufficient condition for transitional justice, developments in the rule of law have contributed to transitional justice and the success of the transitional justice measures may in turn enhance the rule of law. The implication is that there is a loose but not essential association between the two, and when justice is pursued, rule of law is also pursued, and sometimes by coincidence they reinforce one another. What is involved in the transitional justice mechanism? A variety of tribunals, courts, commissions, and local conflict resolutions processes exist and are drawn upon in post-conflict situations. International and national local actors are involved, and the precedent for international tribunals was set when the Nazi and Japanese military political leaders who committed war crimes during the World War II were tried before international military tribunals in Nuremberg and Tokyo. International tribunals are important when at the national level there is either a lack of capacity, where at national level there is lack of capacity, or the courts are established outside the countries. If it is felt that holding the trials internally could fuel tensions, the downside, however, is that in both cases there is little local ownership of the process, and ordinary citizens feel disconnected from the high-level process taking place outside their countries. Mixed international and national mechanisms are also increasingly being used to creatively address a country's specific needs and concerns. In East Timor, for example, the special panels with exclusive jurisdiction over serious crimes were established in 2000 within the domestic judicial system, but with 2 international judges and 1 Timorese judge. The Iraq War Crimes Tribunal, set up in 2004, offers yet another model, with Iraqi lawyers and judges using Iraqi and international law to try former officials. In the case of the Chilean dictator, General Augusto Pinochet, he was arrested in London on charges of murder, torture, disappearances, and the matter was brought forward by a Spanish court. The application of public and customary international law in this case was viewed by others as so divorced to transitional justice, for the local people didn't feel proximity to whatever decision that was taken, for it was recognized by others as an alternative suited for its purpose, since some perpetrators remain influential even after having left office. This is meaning that an international law application can be viewed as intrusive, but some would perceive it as a better alternative, for much of these dictators remain influential even after leaving offices. The dilemma of a new regime. A new regime is likely to face a dilemma that is through loss of experienced technocrats. If prosecutions and the lustration, which is the restoration of credibility to a government by purging perpetrators under an earlier regime, clears way to adherence to the regime, to the new regime, and by holding on to the perpetrators under an earlier regime clears way to adherence to the new regime. And holding on to old regime and their apparatchiks may pose a problem. Old regime functionaries may hold on to monopoly on administrative and technical expertise in the ordinary business of the government. This may take or make the perpetrators indispensable to the new regime. The above depicts the personnel dilemma faced by new regimes and was encountered by West Germany in the period of World War II. Its courts were supposed to be closed for 10 years, awaiting educating a new generation of judges. Transitional justice can also cause unsettling of property rights. The availability of jurisprudence accessed testify that current property holders may receive credits if they have improved the properties. They are sometimes allowed to keep the property, in which case original owners are to receive compensation. Other states may use revenue to finance such processes. Such methods were adopted in the Czech Republic and Hungary. In such programs, they are sometimes viewed as to unsettle property rights through restitution. It is advanced by other viewers that The post-transition economy must generate substantial wealth if it is in a market economy, which recognizes property rights without being driven by utilitarianism as propounded by other jurists. Many pre-transitional states have been characterized by government taking property from economically advantaged individuals to those economically disadvantaged. The property is sometimes given to the poor, displaced people, workers or farmers, or the elite will take a chance to prioritize, to patronize and self-aggrandize. In most cases, confiscations would have occurred long before the transition. Then, property holders at the time of the transition are not the original transferees. They are usually the children or grandchildren of the transferees, or are purchasers of such properties. The popular situation is that after the transition, the original property holders, their relatives or descendants, want to reclaim the dispossessed properties, and in many states, these claims have been successful. In continuation, we are going to look at transitional justice and its fluidity. Socio-economic rights must be part of social reconstruction in divided society because the lack thereof lies at the core of conflicts and is the aim of transformation. Academic literature in conflict resolution has widely acknowledged that economic problems lie at the core of armed conflicts and other manifestations of social clash. In particular, three broad economic and social factors have been identified as potential sources of internal conflict, which are economic problems in the form of lack of insufficient economic growth, discriminatory economic systems, and negative or unbalanced consequences of economic development and modernization, as Kofi Annan, former UN Secretary General, noted. The proximity cause of conflict may be an outbreak of public disorder or a protest of a particular incident, but the root cause may be, for example, socio-economic inequalities and inequities, systematic ethnic discrimination, denial of human rights, disputes over political participation, or long-standing grievances over land and other resource allocation. Most constitutions are framed with the equality clause, stressing the importance of equality and non-discrimination as an obligation of the state parties to the International Covenant on Economic and Social Rights, with particular attention to most vulnerable groups. They must be protected by the adoption of relatively low-cost targeted programs. Failure to do so flies in the face of the obligation to respect, protect, and fulfill as guaranteed of socio-economic rights under the tri-dimensional level of obligations. Then we can talk about the position of women in transitional justice. International humanitarian law provides equal protection for women and men. The four Geneva Conventions of 1949 and their two additional protocols of 1997 also recognize women's special needs, and they are supported by CEDAW, Maputo Declaration, among others. As a result of advances at the ICTY, sexual violence is now recognized as a grave breach of the Fourth Geneva Convention. Sexual violence, including rape, is a violation of law and customs of war and constitutes torture. Few women in transitional processes are in leadership positions, and this is exemplified on the UN Development Fund for Women, in which for the 14 permanent judges of the International Criminal Tribunals of the former Yugoslavia and Rwanda, no more than 3 at any one time have been women. In addition, there is ample evidence to indicate that the adversarial and public nature of trials and tribunals offers limited protection for women witnesses. At the ICTR, for example, even though rules and procedures addressed witness protection and included specific provisions for women. These were not initially put into operation, and women feared testifying. In continuation, we are talking about transitional justice as an overarch. Transitional justice permeates all aspects of life, and so is the concept of transformative constitutionalism. This is exemplified in the case of Mtsuri versus Minister of Justice, Legal and Parliamentary Affairs. It marked a great departure as it showed that transitional justice is a transitional tool from Section 22, subsection 1 of the Marriages Act, which was invoked together with Section 78, subsection 1, as read with Section 81, subsection 1. It was concluded that Section 22 was ultra vires the Constitution. The same case also vindicated the locus standi through Section 85, which is expounded by Maposa, who opines that for one to have legal standing, he needs not to have suffered material harm, but that public interest is open-ended, value-laden, and amorphous concept, which does not have a closed list of categories. In the Greatermen's Stores versus Minister of Public Service, Section 85.1 was invoked, challenging the constitutionality of Section 18 of the Labour Amendment Act. The transitional provision, as read with Section 12 of the Labour Act, Chapter 2001, as it retrospectively imposed on all employers who terminate employees' contract on notice on or after 17 July 2015. The imposition of such financial obligation was justified on the grounds that there is no constitutional provision which prohibits the use of retrospectivity. The basis of the challenge was emanating from the Nyamande and another versus Suva case. The context of transition justice is also seen through the jurisprudence in the case of Nwamita Shilovana, where the customary primogeniture rule was contested between cousins for its patrilineal character. The South African Constitutional Court, as per the pronunciation of by Van Wiesen J., stated that the legal status of customary law norms could not depend simply on their having been consistently applied in the past, since that was a test any new development would fail. It held that the court could pay deference to the communities to develop their law, taking into consideration the need for flexibility in customary law, considering the development of law and the current practices against the non-discriminative provisions of the South African Constitution. The broadening of the locus standi to litigate has given also birth to what are called public interest litigations, which is becoming significant in areas such as mining and environmental law, depicted in the case of Zela versus Yongjing, where a Chinese company was allowed to mine in Wanke National Park. It was interdicted through the active participation of the communities there. In Zela versus Zanjin, the public litigated and were granted a declaratory order and an interdict in their favor. And also in Shangan Holistic Private Limited versus Pele and Mineral Exploration, a transition was marked for environmental rights litigations as provided in Section 73 of the Constitution. The ruling ignored such technicalities and focused on the merits of the case and marked a transition in legal, economic, and environmental implications. The Constitution of Zimbabwe provides for equality and non-discrimination under Section 56, and such does not mean identical treatment in every instance. Preferential treatment may be given to disadvantaged groups in society. Section 56, subsection 3, as well as in Section 56, subsection 5 of the Constitution of Zimbabwe, which provides for unfair discrimination aimed at addressing past injustice. This calls for people who benefited from economic advantage position not to resist transition in order to maintain the elite status. In the name of human rights, as in the case of Mike Campbell versus Minister of National Security responsible for land and land reform, the compulsory acquisition of land owned by white farmers or occupied by white farmers was held not reversible by the Supreme Court. No compensation had been paid to the appellants. The then Chief Justice Chitepo pronounced that the legislature had lawfully ousted the jurisdiction of the courts of law in land-related matters, and the court lacked the institutional competence to deal with such matters despite the violent nature of the program as viewed by others. Section 56 of the Constitution is powerful and cannot be constitutionally challenged if it is fairly discriminating to balance the injustice of the past, as reflected in the case of City Council of Pretoria versus Walker. And according to Moyo, when he concurred with Sachs J, the compulsory acquisition of land in Zimbabwe only coincided with race, but was transitionally justified, and that cannot be taken as meaning the whole process was constitutional. However, in the Grootboom case, South Africans invaded land earmarked for low-cost housing and they were evicted. But through Article 2 of the ICESR on progressive realization of rights, Section 7, State Duty and Bill of Rights, Section 26, Right to Housing, Section 25, Equitable Land Rights, enabled them to access temporal relief on the basis of social and economic rights. This is taking us to the Gabe, the then Chief Justice, and Chitepo's jurisprudence. The controversy of the land reform program in Zimbabwe is associated more with the approach adopted by the government. The national consensus is that land reform was necessary to remedy the historical imbalances in land, where 4,500 whites owned 11 million acres of arable land, while black majority was allocated 16 million acres. The African Commission's fact-finding mission on Zimbabwe also recognized that land reform was critical to Zimbabwe, but could not agree that it was a divisive issue, contrary to the government's assertion. In the process of acquisition, the role of the courts was prominent. And in the Commercial Farmers Union case, the Gabe bench noted that there is no dispute that land reform is necessary and indeed essential for the future prosperity of Zimbabwe. It further noted that for such a matter of national importance meant to rectify historical imbalance, there was need for a program to be in conformity with the law. The Chitepo on the same issue concluded that land was a political issue, needing political solutions, and the court had a limited role. In the Minister of Lands versus Commercial Farmers Union case, the bench confirmed its role to seeing if the procedures were followed, but not to marry that to the factual circumstances obtaining on the ground. Thus, even if the contention that there was lawlessness and criminal acts on the farms was unassailable, the court in that case went ahead to certify that the land reform was in accordance with the law. The approach by the Chitepo bench was criticized and contributed to the perception that the judiciary was rubber-stamping executive lawlessness. In another view, the judges were under the sedation of legal realism doctrine, which demean the legal rules for what judges do becomes important, and the will of those creating the rules. Such an approach is counter-transitional justice, for it is one-sided and has a strong inclination to revenge. Transitional justice, a contemporary view of the Zimbabwean experience. In Zimbabwe, transitional justice became a central issue in the wake of the 2017 ousting of long-time dictator Robert Mugabe and the subsequent efforts of the new government to reconcile and move forward as a nation. Hence, the need to explore the concept of transitional justice in relation to the country's history. Others argue that the history is marked by a long period of authoritarian rule and political violence from the days of colonialism and the liberation struggle. The British rulers pelted and mutilated human rights, including property rights, as reflected in the Morris-Carter Commission, which gave exclusive ownership of land to the white minority. President Robert Mugabe and his party, for almost 4 decades after independence, ruled the country and human rights abuses were widespread. The litmus test, therefore, for transitional justice in Zimbabwe is the Kukuraundu massacres that took place in the 1980s. The massacres, which were perpetrated by Mugabe's government against the Ndebele minority, resulted in the deaths of an estimated 20,000 people. And Mugabe himself, at some point, acknowledged by saying it was a moment of madness. In 2018, President Mnangagwa established a commission of inquiry to investigate the Kukuraundu massacres and to provide recommendations for redress. The commission report was released in 2010 and its results are yet to be implemented in the form of establishment of national memorial to commemorate the victims, reparations, and reconciliation to take place. Another milestone is yet to be witnessed in terms of implementation of transitional justice in Zimbabwe, with the establishment of the Zimbabwe Independent Complaints Commission. The matter was raised by a political violence survivor in the Chironga and another versus Minister of Justice and 3 others. In terms of section 210 of the Constitution of Zimbabwe, there are several cases of human rights abuses which are awaiting to mark a new trajectory as recorded through the judiciary, such as the Mukoko versus Attorney General, where prosecution was stayed due to torture on the victim by the state agents who are not even the police. In Virginia Taylor versus Minister of Defense, the Zimbabwe National Army was sued for soldiers assaulted the lady in Glenview, Harare. The Chauke versus Mare Supreme Court case of political violence in Chire's North constituency is another unresolved matter for victims, remain victims until transitional justice mechanisms are incorporated. All these and other issues fly in the face of an appointed National Peace and Reconciliation Commission, which its achievements are yet to be witnessed. In conclusion, the presentation has unmasked transitional justice as a process that seeks to address past human rights violations by establishing accountability and to confront the impunity of state agents or non-state actors who have committed human rights violations. A successful transitional justice process should include measures to acknowledge the harm done to victims, provide restitution, and institute reforms to prevent a recurrence of the abuses. It has been highlighted also that transitional justice helps in the development of law. For when new situations present themselves, legal means should be available to facilitate any transition and to encourage participation from local people and local remedies. It has also been shown that transitional justice broadens the local stand. And on the flip side, it has been revealed that transitional justice can undermine stability and national security, particularly in countries where there are ongoing conflicts. For example, in Rwanda, the truth-telling processes of the local courts resulted in some instances of violence against those who acknowledged their role in the 1994 genocide. Transitional justice in certain situations forces solutions on the victims due to its restorative approaches. And further to that, the processes may not be an effective deterrent for future human rights abuses, particularly if the perpetrator of these abuses hold positions of power. In Zimbabwe, the ruling party has been accused of using violence against opposition parties and to suppress dissent. A transitional justice process may not be able to address these issues effectively if members who are alleged to be perpetrators feature in critical roles in transitional justice processes. Also, it has been shown that transitional justice process can be resource intensive and costly, requiring significant financial and human resources. Thank you.